I filed for stay vacation. Degree was passed in पास्ट में टाइटल सूट नंबर 16/2011 सेकंड अपील इज पेंडिंग
You are the respondent.
Yes.
Who is for the appeal? And what is the status of the case?
I don't know status में not second appeal is pending. I have filed I have for stay vacation.
I just don't know. You are not aware what is the status. The parties have appeared.
Yes.
Who is the appellant?
Appellant is Lord Salim Akhtar.
अब थोड़ा सीनियर लोग से समझ के mention.
From supplementary list for to be mentioned case item 3 for civil 152 or 2012.
This one. Bus. BUSTL. Paper number 152 of 2012. This matter has been listed at the instance of the office. On account of certain typographical errors. In order dated 25/8/2020. Review of the office note. The following amendments, the word duly boasty in the cause title with respect to pillar number 1 is ought to have been Dindli Basti office notes list. And the respondent number 2 to 13 as shown in the cause title deleted by the order dated 28/9/2022 ought to have been Appeal number 2 to 13 deleted by the order dated 28/9/2022. The review of the office note order dated 25/8/2025 is hereby modified, and the acoustic errors in the order in the order is hereby corrected. The office is dedicated to carry out necessary correction in the order dated 28th of August.
May I be permitted to make a small request in this case? So, to the extent FA 152 of 2012 is concerned, only Uttam Kumar Mehta is the surviving appellant. Just to avoid confusion, all the rest of the appellant's name may be deleted from the cause list.
Uttam Kumar Mehta is only the surviving appellant. I don't know. You can't have a submission like this.
Ladyship, appellant number 2 to 13 has already been deleted.
Yes.
And Shanti Devi's name is also deleted.
Yes.
So only Uttam Kumar Mehta is left.
So it's there. It's apparent from the cause title itself.
But
From subordinate list, item 1, second appeal 190 of 2003 along with item 2.
Ask for this and dismiss.
But he has already placed the lower trial court's order. But the Lordship will allow him, but I can not see.
Let him complete it.
Yes, yes.
Sorry. अभी इस नाटक को सुनने में टाइम लगेगा. Yes, please.
So,
Summarize yesterday's argument and then proceed.
the case is like this. Plaintiff was a teenage under defendant number 1 and 2, right from 1953. And there was an agreement on 6/10/83 with the defendant number 1 and 2 for sale of the premises which is in occupation of the plaintiff. Sale deed was executed in which it is mentioned that the deed of sale is to be executed within 6 months from the date of execution of the agreement. And within that period, the defendant number 1 and 2 had sold off the property in suit to defendant number 3 and 4
When?
on 6/4/2000 and 1984.
And you filed a suit for specific performance? When?
Soon thereafter, I filed on 5/11/5/20, 1984.
11/5/1984. Suit filed. You challenge the sale deed also? No. Not required. You challenge the sale deed also?
Just referring the
Yes, yes, they have.
Specific performance and sale, challenging the sale deed.
It was filed on 21/5/1984. not 21/5/1984.
That's
The prayer is
That's right, yes, sir. File is for specific performance and also for cancellation of DT.
no. No. It is for declaration that the sale deed is null and void, illegal, invalid, and not binding on the plaintiff.
That is only delay. You did not file a suit for specific performance.
Yes, suit for a specific performance, but not cancellation, but declaration that it is null and void, illegal, invalid, and not binding on the plaintiff. In the suit, the defendant appeared to file their counter written statement denying the execution of the agreement. And in the entire defense, they have not uttered a word that the time was essence of contract or after completion, after the time which is fixed in the agreement, they have executed the sale deed.
No, but it is within 6 months, so you said that it has been executed within 6 months.
Yes, within 6 months from.
And 6 months was stipulated period in the agreement also.
Yes.
So,
And there is a clause ki if the vendor will not execute the sale deed, the vendee has every right to file the suit. That is specific.
that's right, it's okay. So time is the essence, where is the requirement?
So therefore, time was not essential contract so far immovable property is concerned.
No. You are not, you are the plaintiff, right?
Yes.
Within the 6 months,
Yeah.
right? They did not wait for the 6 months period.
Yes. Even without waiting 6 months.
They have executed. So there is a question of time being the essence or not essence.
Yes.
It is irrelevant. Because you were given 6 months time
Yes.
to make payment and get the deed executed.
Yes.
But before you could take steps, right? They executed the same.
Yes.
What amount did you pay?
I paid ₹5,000 as advance amount and deposited the consideration amount soon after filing of the suit.
Just a moment.
Suit was filed on 21/5/84
Paid 5,000
at the time of
agreement.
agreement.
What was the consideration amount?
30,000.
Remaining is 25,000. And when did you deposit it in the court?
There was order on 1/6/84 to deposit the consideration amount which I deposited on 9/7/84. 10/7/84. 10/7/84.
Okay. This money, where is this money?
It is deposited in treasury in the court's account. And in the agreement, there was a stipulation
But I have lordship's
that the first party now agree.
No, now you just tell us what happened thereafter. You have, the suit was decreed,
Suit decree.
suit decreed, right?
All the defendants conjointly filed appeal.
Okay. Then the appeal,
Appeal
first
is
appeal, what
decided.
happened before the first appeal, first appellate court?
First appellate court has not formulated any point of consideration or consideration.
Has otherwise considered the point?
The point which were not involved in this suit. I may be allowed to read para 7 of the trial court judgment, internal page 46. Now, this appellate court will consider on the basis of evidence on record as well as legal position as to whether the impugned judgment passed by the court below is fit to be confirmed or is liable to be set aside on the
That is the point
ground
for
taken.
determination. What is? This is it. It's framed not properly, but broadly worded. This is what the court is considering.
Yes. So court has mainly taken the point for consideration whether the judgment of the lower trial court is correct and sustainable or fit to be set aside.
That's right.
Then
What is the finding?
the finding portion. Paragraph 12. In Title Suit 56 of 84, Govardhan Thakur, plaintiff, appears to have brought the suit against Deepak Mitra and others defendant for relief before the court for passing decree in his favor and is sale deed executed by defendant number 1 and 2 in favor of defendant number 3 and 4 dated 6/4/84 being declared null and void.
Yeah, keep quiet. Why are you reading this?
How the learned lower appellate court proceeded.
You just come to the finding of the lower appellate court.
Then page 49. On the other hand, learned counsel for the plaintiff argued that after considering the evidence as and assigning reason, the learned court below came to the conclusion finally that the alleged agreement for sale dated 6/10/83 Exhibit 4 is a valid document and binding upon the parties. After perusing the impugned judgment of title suit number 56 passed by the learned Subordinate Hazaribagh, and after careful consideration of the evidence oral and documentary available on record along with the argument advanced on behalf of the appellant and respondent, I find that alleged deed of agreement dated 6/10/83 Exhibit 4 may be forged document or it may not be forged document, especially when the learned court below himself written at page 20 of the impugned judgment that the signature of Hira Mitra, defendant number 2, could not be proved by adducing evidence on behalf of the plaintiff. However, since two views are possible, one leads to this conclusion that alleged agreement of sale Exhibit 4 may be a genuine document, and another circumstance lead to this conclusion that the alleged agreement of sale dated 6/10/83 Exhibit 4 may be a forged fabricated document. When the learned court below appears to have come to the conclusion after due discussion of evidence that the agreement for sale dated 6/10/83 is a valid document, in such circumstances I do not think it just and proper to disturb that finding of the learned court below. So the learned lower appellate court has not think himself to deal with this finding and accepted this. Just and proper to disturb the finding of the learned court below, especially when the learned court below appears to have assigned reason for the same in the impugned judgment. Therefore, on that ground alone, I do not think it just and proper to set aside the impugned judgment in the facts and circumstances of the case. It is the primary duty of the plaintiff to prove its case satisfactorily as per his pleading. Because the pleading are not evidence, therefore this fact has to be ascertained in the light of the argument advanced on behalf of the plaintiff, respondent, and defendant appellant. The plaintiff has alleged that after the alleged agreement for sale, the plaintiff many times approached the defendant 1 and 2 to register and execute the sale deed, but the defendant on various pretexts took time several times, and on 11/4/84, the plaintiff sent a registered notice to defendant number 1 and 2 to execute sale deed within a month, otherwise he will go to court for a specific performance of agreement. But in spite of this notice, they did not execute the sale deed. To appreciate the evidence as well as the pleading of the plaintiff, I think it is proper to consider the recital of the alleged agreement Exhibit 4. There appears to be a clear recital in the alleged deed of agreement dated 6/10/83 Exhibit 4, which is as follows: that the first party now agree and bind himself that within 6 months from this date will execute the sale deed with respect of the Schedule A property in favor of the second party, and the same be presented for registration, and he will receive the rest rupees 25,000, the consideration money from the second party. That if the second party does not get the sale deed executed by the first party in fixed time, then his advance money of rupees 5,000 paid to the first party will be forfeited. And thereafter, after that, whatever stipulation in the agreement, the Landed Court of Appeal below has not taken into consideration and not even seen that. Thus, it is clear. And thereafter, what was the stipulation in the agreement? That if the first party refuses to execute sale deed in respect of Schedule A property to the second party within the time fixed, then in that case the second party is free to move the court and get the sale deed executed. So this aspect of the matter, this stipulation in the agreement, as the Landed Court of Appeal below has
At the same time, there was a clear stipulation that if the deed is not executed within the period of 6 months, then the amount will stand forfeited.
Yes, it is forfeited. And it is also, there is binding, it is binding on dependent also to execute the sale deed in favor of the.
How will they execute the sale deed when you are not?
When I requested,
When did you request?
I requested several times.
When?
I have stated that I have requested.
Show me any request within 6
And
months.
on 5,
Show
11.
me any request within 6 months.
Yes, and on 11/5/84, I sent a notice.
That is after expiry of 6 months.
So that is stipulation in the. So far the time issuance of contract is not with respect to this property in view of the agreement, that there is a stipulation that if the defendant will fail to execute, the plaintiff has every right to sue. Therefore, sue for a specific performance of agreement. And soon after, within the period on 6/10/84, the defendant number 1 and 2 have sold out the property in favor of the number 3 and 4. Within this time, at least they would wait till 6.
So when you are seeking specific performance of contract, then you have to prove your readiness and willingness throughout.
So readiness and willingness, if it is the case of the defendant, then I have to prove the readiness.
Even
Yes.
if you have to, otherwise also.
In
You
the
have to plead
entire
and prove.
pleading,
You have to plead and prove
so
your
my
readiness
readiness,
and willingness, irrespective of whatever the standard court takes,
so
because the statute provides. As per the provisions of the Specific Relief Act, it is for the plaintiff to plead and prove the readiness and willingness to
So,
perform his part of the contract
in the plain,
throughout.
yeah,
It has to be throughout.
yes, in the plain, from the date of agreement On the date of agreement, I paid rupees 5,000.
That's after taking loan of rupees 1,000.
So from wherever,
Wherever.
yes.
That's right. That's
and
right.
therefore there is.
No, therefore show me your readiness and willingness to
So
perform
readiness
the
and
part of the
willingness
contract during 6 months.
it can be gathered from the facts that soon after filing of the suit, I deposited rupees
That is
25,000.
not sufficient. That is not sufficient. You have to show your readiness and willingness even as per the contract.
So I have stated in my pleading and in evidence. I will go through the evidence also in pleading para 12, 13 and 14 of my plaint that I have stated all these facts, readiness and willingness. But how the learned lower appellate court has dealt with the judgment under appeal, thus it is clear from the perusal of Exhibit 4 that the plaintiff Governor Thakur had to deposit rupees 25,000 within 6 months from date of alleged agreement for sale dated 6/10/83 to show the readiness and willingness of the plaintiff to purchase the suit property. Therefore, it is the bounden duty of the court to ascertain the readiness and willingness of the plaintiff Governor Thakur to make payment of the rest consideration money amounting to rupees 25,000 out of full consideration money of rupees 30,000. The learned counsel for the appellant defendant argued that the period of 6 months in Exhibit 4 dated 6/10/83 expired on 5/4/84. It was argued that there is absolutely no reliable evidence or record to prove that the plaintiff was ready and willing to get the sale deed executed within the said period of 6 months from 6/10/84. 6/10/83. DW8 Ira Mitra has categorically stated in paragraph 5 of her evidence that she had never any conversation with the plaintiff Govardhan Thakur. Neither Govardhan Thakur came to her residence nor she visited his shop. In paragraph 5, she stated that neither Govardhan Thakur had any talk for sale of the disputed house nor had any talk with Govardhan Thakur for sale of disputed house. DW6 Deepak Mitra has categorically stated in paragraph 12 of his evidence that there was no negotiation with respect to the suit property between him, her mother and plaintiff. In this respect, much argument was advanced on behalf of the plaintiff with respect to the notice exhibit 1 dated 11/4/84 showing the readiness and willingness of the plaintiff to purchase the suit property from defendant number 1 and 2. In this connection, there appears to be force in the argument advanced on behalf of the appellant that no legal value can be attached with the advocate's notice exhibit 1 alleged to have been sent on behalf of the plaintiff Govardhan Thakur to defendant number 1, 2 and 2 Deepak Mitra and Ira Mitra after expiry of 6 months, that is beyond the period of 6 months from the date of agreement to sale dated 6/10/83. As a matter of fact, sending notice after the expiry of the period of 6 months from the date of agreement to sale cannot be construed as readiness and willingness on the part of the plaintiff within the said period of 6 months from the date of agreement. Over and above, PW5 Govardhan Thakur plaintiff in para 40 has stated that he paid rupees 5,000 to defendant number 1 Deepak Mitra after taking loan and only meager amount was with him, and he clarified further that only 4,000 was with him and the rest rupees 1,000 was taken by him on loan. And this evidence, the learned counsel for the defendant argued that plaintiff was not financially sound to pay the rest consideration amount of rupees 25, and that is also a circumstance against the plaintiff to this effect that he was not ready and willing to perform the part of the contract within the period of 6 months from the alleged date of agreement. It is also made clear that deposit of consideration money remaining in the court after filing of the suit number 5684 dated 21/5/84 does not carry weight since that has not been deposited within the period of 6 months as stipulated in the sale deed of agreement dated 1683, and that does not show that the plaintiff was ready and willing to perform the part of the contract and agreement, if any, took place. Even in the evidence in para 7, the plaintiff Govardhan Thakur does not say that he was ready and willing to perform the recital of the agreement within the period of 6 months, and his readiness for making payment and to fulfill the condition of the agreement after expiry of 6 months does not help the plaintiff in the facts and circumstances of the case. Surprisingly, there is no averment even in the plaint that the plaintiff was ready and willing to perform this part of the contract and to get the sale deed executed and registered within the said period of 6 months. So it is error of record. In the plaint there is mention. In the plaint there is mention.
That is not sufficient.
And especially when readiness and willingness was not at issue, because the defendants have not challenged, have not attacked about that they were not ready, therefore they executed the sale deed. And the plaintiff was not willing or ready to get the sale deed executed. What the plaintiff has stated in his plaint, that the plaintiff had applied to the defendant especially to perform the agreement on his part.
Which para of the plaint are you referring to?
Paragraph 12, that the plaintiff.
agreement. Para 12 of the plaint.
12, 13 and 14. That the plaintiff has applied to the defendant especially to perform the agreement on his part, but the defendant 1 and 2 have not done so, and they have refused to do so. That the plaintiff is still ready to purchase this property and is still ready to pay the balance consideration amount money of rupees 25,000 to the defendant number 1 and 2. That the plaintiff has been and still is ready and willing especially to perform the agreement on his part, on which the defendant have notice. Then what they replied, their reply is also necessary to be looked into in the written statement. That is in the written statement at para 17, what the defendants have stated, that the statement and allegation made in para 12 of the plaint are incorrect, false and denied. To avoid repetition, the averment made in the foregoing paragraphs are referred for details. It is further asserted that the plaintiff never applied to the defendant, to this defendant, to specifically perform the alleged agreement, and nor there was any refusal and as alleged, nor there was any occasion for the same. The statement made in paragraph 13 and 14 of the plaint is incorrect, false and self-serving, and are denied in toto. There was no agreement to sell in favor of the plaintiff by this defendant as alleged, and hence question of readiness and willingness with notice of the defendant does not arise at all. So main contention of the defendants were that there was no any agreement for sale with the defendant, with the plaintiff.
No, apart from that, they have also denied your readiness.
Yes. So
They have denied that you never approached them. They have denied.
I assert they denied. I also laid evidence and they have also laid evidence. And on the basis, when there was no issue with respect to readiness and willingness, and defendant have not contested the suit on the ground of readiness and willingness, rather they denied the execution of the cell deed. From very beginning they questioned the sanctity of this, genuineness of the sale agreement. Therefore, in the judgment, surprisingly, there is no affirmation even in the plaint that the plaintiff was ready and willing to perform his part of contract and to get the sale deed executed and registered within said period of 6 months. The learned counsel for the plaintiff has only argued that the learned court below has a right at conclusion that the plaintiff was ready and willing to perform the part of the contract, and for that sufficient reason have been assigned as such. There is no reason to disturb that finding by the appellate court. After careful consideration of the impugned judgment, I find that the learned court below at page 19 of the impugned judgment has mentioned that since the plaintiff has sent the advocate's notice to the defendant appellant and has deposited the part consideration money amount of rupees 25 on the direction of the court, and as such it would be presumed that the plaintiff was ready and willing to perform the part of the contract for the execution of the sale deed with respect to the suit properties. I find that apparently the land court below appears to have ignored the contents of the alleged agreement for sale dated 6/10/83, which speaks very clearly that the time was the essence of contract and that time was fixed for a period of only 6 months from the date of agreement dated 6/10/83. There is clear recital in the alleged agreement dated 6/10/83. It's before that within 6 months from 6/10/83 the plaintiff shall pay the part consideration amount of rupees 25,000 to the defendant number 1 and 2. Otherwise,
Any judgment you want to cite?
first of all, that time was not essential contract.
So you could have filed your case in 3 years from after the expiry of the period of 6 months.
the limitation is provided in the limitation act.
So it
3
will be
years.
governed by 3 years. So
it
they
is-
were supposed to wait for 3 years.
No.
Then
It is not.
you could have filed after 3 years also, within 3 years. That is the limitation.
So for filing of the suit is concerned, one can file even after 20 years.
No.
But that can be
No.
whether that can be adjudicated
No,
or
no,
that
the
can
point
be
is, please appreciate
Yes.
this. I just want to know from you that according to you, 3 years period would be applicable.
Yes.
Right?
According
So
to
from the,
law. As per
that's
law.
right. According
Yes.
to you being a counsel will always speak according to law. You are expected to speak according to law, right? So according to you, after expiry of 6 months, still there was a period of 3 years, and time was not the essence of it.
Yeah.
This is what you want to say.
That has been held. That has been held.
Held where?
In several judgments allowed.
दिखाइए एक judgment दिखाइए. Please cite the judgment.
it is a decision reported in AIR 1977 Supreme Court page 1005.
AIR 1977
Supreme Court
1005.
Para
Yes.
5 there.
Give me a book. Give me a. You have a copy? Para 5. सर हमारी कॉपी दे दीजिए आप किससे पढ़ेंगे
एक लाइन हम पढ़ देते हैं
एक लाइन हम जजमेंट से एक लाइन पढ़ें
हम दे देते हैं
मतलब आई रीड इट फॉर माई सेल्फ वेयर इज योर आप साइटेशन का किताबें भी देते हैं आप यहाँ दिए लिस्ट ऑफ बुक्स
Fixation of the period within which the contract has to be performed does not make the stipulation as to time the essence of contract. When a contract relates to sale of movable property, it will normally be presumed that time is not the essence of contract. The intention to treat time as essence of contract may be evidenced by the circumstances which should be sufficiently strong to displace the normal presumption that in a contract of sale of land, stipulation as to time is not the essence of contract, and it has been relied upon one judgment of the Supreme Court, 1967 Supreme Court. The next paper.
1977, 97, 97.
77 अभी लिखा हुआ है 67 सुप्रीम कोर्ट 686
67 का पेज
1967 सुप्रीम कोर्ट
पेज
868 और ऐसा नहीं है जैसे ही मुझे पता चला जवाब दिए कि हम तो बेच चुके हैं तो तुरंत सूट फाइल कर दिए हम तो रिक्वेस्ट कर ही रहे थे अंत में 11/5
उन्होंने आपके लीगल नोटिस का जवाब दिया
यस
एग्जिबिट अपना लीगल नोटिस और उनका एग्जिबिट दोनों बताइए This agreement is exhibit 1. ये exhibit 1 है ना ये agreement
Agreement is exhibit 4.
exhibit
4.
That's all. That's all for this case.
So therefore, my submission is that learned lower appellate court had diverted himself from the fact of the cases. Defendant never raised the issue of readiness and willingness or the time is instance of contract. It was nowhere stated. And how the learned lower appellate court has come to the conclusion that time was essence of contract and there was neither readiness and willingness, and under what circumstances they have argued, the defendant had argued his case in appeal when there was no pleading. There was no pleading at all on this point. Therefore, the substantial question of law that has been formulated,
The fact as to whether the time was the essence of the contract can be seen even from the agreement.
yes, madam?
Terms and conditions of the agreement, because that has been held to be a valid agreement.
Yes.
So therefore, terms and conditions of the agreement is something which is required to be seen.
So no one can presume that no one
So there is
can
no question
presume
of
that
presumption. There is no question of presumption. We have to see the terms and conditions of the agreement and find it out from there itself. The time was the essence.
the time was till 6/10/2024.
That we will see. That's right.
And on 1684 itself he executed sentence in favor of different number 3 and 4
So time was still
till 6/10/1984. Though they have argued that time was 1683
6/10/83 is the date of agreement. 6 months is 5/4/84.
No, it is 6/4/84. As per my calculation, it is 6/4/84, and there is judgment to that effect also. The time will be counted. How the time will be counted? So there is one judgment on this. By the under clause in the under clauses act definition section 335, it deals with month.
General Clauses Act. It deals with month, right? 6 months means 6 months.
6 months means 6 months. So how it will be counted? By the word within a month. In this case, my lord, what happened? The court has granted time to deposit the cost within a month. On 25/10/1948, and the cost was deposited on 25/11/48, but it was refused to accept, saying that it is beyond time. The Honorable Odisha High Court has held that by the word within the meaning of this month, the subordinate judge in his order dated 25/10/48 mean that the sum of ₹100 should be deposited before 26th November 48. That is to say, before expiry of the court's hour on 25th November 48. Hence, on 25th November 48, the case did not stand automatically dismissed, and the court should have waited till the expiry of the court hour on that day. So it
On 25th it was deposited.
yes. So it is not that time was granted, today time is granted to deposit within a month. So if it is 11th,
ये कौन सा जजमेंट?
then it
सर आप हमको बताइए, आप सेकंड अपील बहस करते हैं, आप एक कॉपी हमको नहीं देते हैं, आप लिस्ट ऑफ बुक्स नहीं देते हैं. सॉरी क्या बोलना है? सॉरी आप हर केस में ऐसे ही करते हैं. You have no regrets. What is this? We will not take consideration of your judgments, which you keep it for yourself, and you are not able to place the judgment.
I'm just placing.
Then you keep it for yourself. I don't have a copy.
I am placing the book itself.
तो क्या book itself? If I want to ask a question from this judgment, you will not be able to answer. You say that I don't have a copy now.
I am.
You are supposed to place the judgment, not one line from the judgment. List of books भी नहीं दे सकते.
This is fault on.
Print we are not asking from you. So क्या है?
So the
If we give 1 week time to remove the debate till 5 o'clock.
Yes.
So what's the big deal about it?
So on 6th.
On 6th the 7th month started. On 6th.
No.
Yes.
My submission is the.
Suppose let us take 1st of January.
Yes.
When will the month end? On 1st of February, or it will end on 31st of January?
So it will end till 12 of 31st of January. 30.
That's right.
Yes.
But you have taken steps on the next day.
No, I have
The
not.
deed has been executed on the next day.
The deed was executed not on the next day.
Yes, of course.
Within 6 months.
Yes,
On
within
6th
6 months.
itself.
Yes. So therefore I am saying, if you have 1st of January as the date, when will 1 month expire? On 31st? Or it
31st.
will expire on 1st of February?
Yes, it will expire on 1st of February.
Right.
Till 31st,
We'll deal with
the
it.
time is there.
We will deal with your argument, don't worry about it.
Taking into consideration.
We will take into
Yes.
consideration. It's correct.
It will only expire.
इनका submissions लिखा है. Essay number 178 of 2003.
May I take a look for a moment?
आपका सबमिशन लिखा है, it's your option. This appeal has been filed against the judgment dated 4/3/2003, within bracket decree signed on 24/3/2003, passed by the 6th Additional District and Sessions Judge Hazaribagh, entitled appeal number 8 of 1992/18 of 2001. Thereby, the judgment passed by the learned trial court has been suspended. The trial court judgment was passed on 29/2/1992, within bracket decree signed on 10/3/1992, bracket close, passed by learned Subject 1 Hazaribagh, entitled suit number 56 of 1984. The suit was decreed. The first appeal was allowed, and consequently the plaintiff is the appellant who votes for. The suit was filed seeking a decree that the sale deed executed by defendant number 1 and 2 in favor of defendant number 3 and 4, while sale deed number 5514 dated 6/4/1984 be declared null and void, illegal, invalid, and not binding upon the plaintiff. A further relief was sought that the defendant number 1 and 2 be directed and ordered specifically to perform the agreement and do all the acts necessary in law, and a decree for specific performance of contract. And a prayer was made for a decree of specific performance of contract, and the defendant number 1 and 2 be ordered to execute the sale deed in favor of the plaintiff. The specific case of the plaintiff was that the plaintiff was in occupation of the property ground floor as monthly tenant since 1953. And the defendant number 1 and 2, being the owners of the property, approached the plaintiff on 6/10/1983 and entered into an agreement of sale with respect to the suit property for the consideration of rupees 30,000. The agreement was executed by both the parties on 6/10/83. The plaintiff paid an amount of rupees 5,000 as a part of the consideration as advance and put the plaintiff in possession. And it was asserted that pursuant to the agreement of sale, the plaintiff was no longer a tenant of the defendant 1 and 2 and became the owner of the property by virtue of the deed of agreement. The defendant number 1 and 2, by virtue of the agreement, agreed to execute the sale deed of the suit property in favor of the plaintiff within 6 months from the date of the agreement, that is 6/10/1983. It was the case of the plaintiff that after the agreement, the plaintiff approached the defendant number 1 and 2 many times to execute and register the sale deed, but the defendant on various pretexts did not execute the sale deed and assured the plaintiff that they will do the needful. The plaintiff waited as the defendant had given the assurance. However, on 11/4/84, the plaintiff sent a registered notice to the defendant number 1 and 2 to execute the sale deed within a month. Otherwise, they will approach the court seeking specific performance of contract. But in spite of notice, the sale deed was not executed. It was further case of the plaintiff that on 25/4/84, the defendant number 1 and 2 sent a registered notice to the plaintiff informing him that they have already sold the suit property to the defendant number 3 and 4 on 6/4/84. And on the same day, plaintiff also received the notice from the defendant number 3 and 4 informing him that they have purchased the suit property and hence they are entitled to receive the rent. It was a further case of the plaintiff that on receiving the two notices, the plaintiff informed the defendant number 3 and 4 that defendant number 1 and 2 had no right to sell the property in view of the agreement of sale entered between the plaintiff and the defendant number 1 and 2 on 6/10/1983. The plaintiff asserted that the deed executed on 6/4/84 by the defendant number 1 and 2 in favor of defendant number 3 and 4 was illegal and void, invalid and not binding upon the plaintiff, and also asserted that from the date of the agreement, that is 6/10/83, the plaintiff perfected right, title, interest and possession of the suit property. It was asserted in paragraph 12, 13, to 17, that the plaintiff had applied to the defendants to perform the agreement on his part, but the defendant number 1 and 2 had not done so, and they have refused to do so. And that the plaintiff is still ready to purchase the sold property and was ready to pay the balance consideration money of rupees 25,000, and was still ready and willing specifically to perform the agreement on his part. It was also asserted that the defendant number 1 and it was also asserted that defendant number 1, the act of the defendant number 1 and 2 is wrong, and that the defendant number 3 and 4 also do not have the right to purchase the property, as they had full information that the defendant number 1 and 2 have already, by an agreement dated 6/3/83, have contracted for sale to the plaintiff. It was stated in paragraph 17 that the cause of action arose on 6/10/83 when the defendant number 1 and 2 signed the agreement, and on 6/4/84 when defendant number 1 and 2 sold the suit land to defendant number 3 and 4, and on नहीं that's all, ये वाला last नहीं लिखना, और 17 तक लिखे ना, 17 का जरूरत नहीं है, 12 to 15, ठीक है? A written statement was filed on behalf of defendant number 1 and 2. Denying the agreement of sale. And it was alleged that the agreement of sale was forged and fabricated. it was asserted that it was false to say that the defendant number 1 and 2 agreed to execute the same deed within a period of 6 months from the date of the agreement. In paragraph 17 of the written statement, it was asserted that the plaintiff never applied to these defendants to specifically perform the alleged agreement, nor there was any refusal as alleged, nor there was any occasion for the same. The statement with regard to readiness and willingness was also denied in paragraph 18 of the written statement. And it was asserted that defendant number 3 and 4 are bona fide purchaser of the suit property. The statements made from paragraph 12 to 16 were denied. The written statement was also filed by defendant number 5 and 6, who adopted the written statement filed by defendant number 1 and 2. And they also asserted that even if court comes to a finding that there was an agreement of sale between the plaintiff and defendant number 1 and 2, though not admitted, the defendant numbers 5 and 6 were not bound by the alleged agreement, since the same has not been executed by these defendants, but was not executed by the defendants on behalf of the defendant number 5 and 6 as a power of attorney holder on their behalf. And therefore it was asserted that the agreement of sale cannot be enforced. So far as defendant number 3 and 4 are concerned, they also filed a separate written statement. and asserted that the agreement was forged and the alleged agreement dated 1683 was forged and fabricated. And it was wholly incorrect to say that the plaintiff was put in possession pursuant to the agreement of sale, rather the plaintiff was already a tenant over the suit property, and that the plaintiff never became the owner of the suit property by virtue of the alleged agreement. The defendant number 3 and 4 stated that these defendants had no knowledge the defendants also assert, these defendants also asserted that since the agreement itself was forged and fabricated, therefore, the question of full information to these defendants of the alleged agreement did not arise at all. The learned trial court framed the following issues for consideration. By paragraph 5 of the judgment. The learned trial court recorded that after considering the materials on record, was of the view that the agreement dated 6/10/83 was duly executed and was a valid document. The learned trial court. Ultimately, defeat the suit. The learned trial court also took into consideration on the point of readiness and willingness. The learned trial court recorded that the plaintiff had given legal notice and the plaintiff had deposited the balance consideration amount before the court pursuant to the order of the court, and therefore held that the plaintiff was and was of the view that these aspects are strong in favor of the plaintiff. The learned court was of the view that the plaintiff was ready and willing to perform as part of the contract, and ultimately I defeat the suit. So far as the learned first appellate court is concerned, the grounds on which the judgment was assumed has been recorded in paragraph 2. The learned first appellate court, by paragraph 7, after recording the case of the respective parties and after recording the case of the respective parties by paragraph 7, observe that the point for consideration of the court was as to whether the impugn judgment passed by the court below was fit to be confirmed or was liable to be set aside on the grounds taken on behalf of the applicant. The learned first appellate court scrutinized the materials on record and confirmed the finding of the learned trial court that the agreement dated 6/10/1983 was a valid document. Thereafter, the learned court went on to examine the other ingredients which are required to be satisfied for seeking a specific performance of contract. On the point of readiness and willingness, the learned first appellate court referred to the recital of the agreement dated 6/10/1983 and observed that it was crystal clear that the plaintiff had to deposit rupees 25,000 within 6 months from the date of the eldest agreement of sale. And examine the readiness and willingness of the plaintiff. The appellant had urged that the period of 6 months in Exhibit 4 expired on 5/4/84, and absolutely there was no evidence to prove that the plaintiff was ready and willing to get the sealed executed within the period of 6 months. And the notice was also given after expiry of 6 months, that is on 11/2/1984. The capacity of the plaintiff to pay was also considered by observing that at the time of making payment of 5,000 rupees on the date of agreement, the plaintiff had taken loan of rupees 1,000, and the remaining consideration amount was rupees 25,000. The learned court also considered the oral evidence and ultimately came to a finding that after an expiry of 6 months from 6/10/1983, the defendant number 1 and 2 were not liable to execute any such agreement of sale in favor of the plaintiff. And that the plaintiff had failed to prove his readiness and willingness to pay the amount within the period of 6 months. It was recorded that defendant number 1, that the title of the defendant number 1 and 2 was clearly admitted and undisputed, and the title passed on to defendant number 3 and 4 on 6/4/84 when the sale deed was executed by defendant number 1 and 2 in favor of defendant number 3 and 4. Until then, no steps were taken by the plaintiff to perform the part of the contract. And as such, defendant number 1 and 2 had every right to transfer their sole property in favor of defendant number 3 and 4. The learned court ultimately held that the plaintiff was not able to prove the other ingredients for grant of specific performance of contract, and therefore allowed the appeal. The learned counsel, this appeal was admitted for finding guilty by order dated 18/7/2006 on the following substantial question. The learned counsel for the appellant, by assailing the impugned judgment, has submitted that no issue was framed with regard to readiness and willingness on the part of the plaintiff to perform his part of the contract. He has further submitted that the period of 6 months from 6/10/83 would have expired on 6/4/83, 6/4/84, and 6/4/84 would be counted as the last date, and therefore the sale deed executed on 6/4/84 cannot be said to be beyond the period of 6 months. He has also submitted that the suit was filed on 21/5/1984, and on 1/6/1984 a direction was issued by the court to deposit the remaining balance consideration amount which the plaintiff duly deposited on 10/7/1984. The learned counsel has submitted that when the defendants were challenging the very validity of agreement dated 6/10/1983 by stating the same to be a forged and fabricated document, the parties did not join issue with respect to readiness and willingness to perform the agreement, and therefore the learned first appellate court has gone beyond the frame of the suit to come to any finding to this effect. The learned counsel has submitted that there was no pleading that the time was the essence of the contract, and therefore, and there was a clear stipulation in the agreement that if the sale deed is not executed within 6 months, it will be open to the plaintiff to seek specific performance of contract. The learned counsel submits that the suit was immediately filed after expiry of 6 months on 21/5/1984, although the period of limitation for filing the suit would have been 3 years from the date of cause of action. However, the immediate step on behalf of the plaintiff to file the suit and also deposit of ₹20, the balance consideration amount of ₹25,000 upon the direction issued by the court speaks volumes that the plaintiff was throughout ready and willing to perform his part of the contract. The learned counsel has referred to the judgment passed by Honorable Supreme Court. कहाँ है judgment दिखाई? दोनों judgment. इसका print लाया? Honorable Supreme Court, in the case reported in bracket 1977, volume 2, SCC 539, Govind Prasad Chaturvedi versus Haridat Shastri. And I submitted that and has referred to paragraph 5 thereof to submit that the fixation of period within which the contract has to be performed does not make the stipulation as to time the essence of the contract. when a contract relates to sale of immovable property, it would normally be presumed that time is not the essence of the contract. The learned counsel submits that the aforesaid judgment fully applies to the facts of the present case, and the time cannot be said to be the essence of the contract, and therefore the substantial question of law is fit to be answered in favor of the appellant. The learned counsel has submitted that the learned first appellate court has reversed the judgment and decree of the trial court in wrong perspective when, and considering the point in connection with which no issue was framed by the learned trial court. The learned counsel has also relied upon the judgment passed by Honorable Odisha High Court reported in AIR 1952 Odisha 279 in order to substantiate his argument that the 6 months from the date of agreement, that is 6/10/1983, would have expired not on 5/4/1984 but on 6/4/1984, and 6/4/1984 being the last date of the 6 months, the sale deed could not have been executed on that day. The learned counsel submits that even till 12 o'clock midnight of 6/4/1984, the agreement of sale dated 6/10/1983 was could have been acted upon. But the defendants did not wait, and ultimately the sale deed was executed by defendant number 1 and 2 in favor of defendant number 3 and 4. That's all. Abul, respondent. इसका जो पैराग्राफ लिखना है 77 वाला, ये इसका पैराग्राफ 5 पूरा नहीं है, 5 and 6 दोनों, और उड़ीसा वाले जजमेंट का paragraph 7 to 10.
Most of the arguments Lord, the appellate court have taken note of, that your lordship has recorded, but only few things what has been argued from the appellant side, Lord. But so far as no issue of readiness and willingness is concerned, which your lordship has taken note of 1, 2, 3, 4 notes. But there was a pleading in the plaint, paragraph 13 and 14 of the plaint, 12, 13, 14. And there is denial by the defendant, landlord, original owner, lords, in paragraph 18. So therefore, there was issue between the parties so far as readiness and willingness is concerned. The trial court also, lords, gave a finding on that. The appellate court reversed. But let us see not the trial court finding first. The trial court only gives 2 reasons for, lords, recording readiness and willingness. This is page 19 of the trial court judgment. It is the same. But the 2 reasons given by the trial court is that मगर वादी के विद्वान अधिवक्ता
page 19
page 19 trial court
कहाँ पर पढ़ेगा मगर हाँ नहीं
और हो सकता है पेज नंबर नीचे होगा कि हम मार्क कर देंगे
नहीं बताइए
जहाँ पे रेडीनेस एंड विलिंगनेस वाला नोट फाइंडिंग है वहीं पे खाली वो दो चीज पे रेडिनेस विलिंगनेस पे कंकर की है ट्रायल कोर्ट में।
मगर वादी के विद्वान
हाँ, मगर वादी के विद्वान अधिवक्ता द्वारा दी गई प्रतिवादी को वकालतन नोटिस तथा उनके द्वारा न्यायालय के आदेश के आलोक में बकाया विषय मूल्य 25,000 रुपए की राशि जमा करने से स्पष्ट है कि वादी बकाया विक्रय मूल्य भुगतान कर विक्रय लेख निष्पादन कराने के लिए वे बराबर तैयार है। So these are two considerations. First is legal notice. Second is deposit of balance consideration, 25,000. So far as this aspect is concerned, my submission is not legal notice have been issued on 11/4/1984. That is after expiry of the 6 months period. The deposit in the court also is Milord's 10/7/84. That is after 6 months. So far as this is factually what is. Now Milord's 10/7/84 and legal notice is 11/4/84. So that is after period of 6 months. Now Milord's, so far as what is the law on this subject?
Just a moment.
Yes.
The learned counsel for the respondents has submitted that although no specific issue was framed in connection with readiness and willingness to perform the part of the contract, but there was a specific pleading on the part of the plaintiff in paragraph 12, 13 and 14 regarding his readiness and willingness to perform his part, and there was a denial by the defendant number 1 and 2. The learned counsel has submitted that even the parties joined issues at the time of evidence before the court, and the learned trial court specifically recorded that there was readiness and willingness on the part of the plaintiff to perform his part of the contract, and this finding was based on two aspects. One was that legal notice was given on 11/4/1984, and that the plaintiff had deposited an amount of the balance consideration amount before the court on 10/7/1984. He submits that both these incidents are admittedly after expiry of the period of the agreement, which expired on
But which expired on 5/4/1984.
5/4/1984.
That is after 6 months, 6/10/83 is the
From
agreement.
6/10/1983, the learned counsel submits that any conduct after the agreement is of no consequence.
Yes. And now, not so far as law is concerned, Your Lordship may kindly have 2023-11 SCC. Not may straight away take note so far as issue of deposit is concerned. Paragraph 46. This was placed note several times, but paragraph 46. Because only 2-3 issues are there. Let us see paragraph 46. But in the middle, making subsequent deposit. I'm sorry, notes I have not marked that because
No problem.
paragraph 46 note making subsequent deposit. Making subsequent deposit of balance consideration after lapse of 7 years would not establish the respondent plaintiff readiness to discharge his part of contract. The reliance may be placed upon Umabai versus so and so, wherein this court speaking to SB Sinha held that the deposit of amount in court is not enough to arrive at a conclusion that the plaintiff was ready and willing to perform his part of the contract. Deposit in court would not establish plaintiff's readiness and willingness within the meaning of section 16C of the Specific Relief Act. So far as first consideration.
Just a moment. On the point of readiness and willingness, the learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2023, bracket clause 11 SCC 775, within bracket Q and Krishnamurthy versus A and Krishnamurthy, and has referred to paragraph 46 and 47 of the same judgment to submit that making deposit of balance consideration amount later on and also deposit of the amount in the court are not conclusive proof of readiness and are not proof of readiness and willingness. Rather, it is rather the plaintiff has to prove his readiness and willingness to perform his part of the contract from the date of execution of the agreement till the date of decree, which is a condition precedent for grant of relief of specific performance. 47 be important. 47. Yes.
Now, not so far as readiness and willingness and payment of the consideration is concerned, But may kindly take note. But 5,000 was paid, it is alleged. 1,000 was taken in loan.
That has.
Yes, that has been recorded below. So far as balance 25,000 is concerned, it is the evidence of PW2, paragraph 18, that after selling of the land of the plaintiff, they got money which they deposited in court. Your Lordship may kindly see this.
Where is it recorded in the improved judgment? Is it recorded in the improved judgment?
Just take note. But
This is PW?
PW2. Yes. दिखाएगा भाई
Pardon me?
Yes. PW2 kindly take. Paragraph is 11.
Para 11.
Para 11. गोवर्धन ठाकुर की बार बार वहां तक सभी अभी गलत नहीं पढ़ते मुझे 60 सदस्य से कोई यानी गोवर्धन ठाकुर का सोर्स ऑफ इनकम बॉम्बे सैलून है तथा डैश में कुछ जमीन है मतलब कोई सम डिफरेंट विलेज में कुछ जमीन है वह रामनगर वाली जमीन को बेच कर कोर्ट में बैलेंस कंसिडरेशन ऑफ मनी जमा किए.
The learned counsel has referred to the evidence of PW2, paragraph 11, to submit that the plaintiff Govardhan Thakur.
नहीं ये प्लेंटिफ का गवाही नहीं बोल रहे हैं प्लेंटिफ का है PW2.
Okay, he is not the plaintiff.
No, he is not.
The
Plaintiff is PW5.
PW2 has stated in his evidence that the plaintiff had taken loan to deposit the initial consideration amount, a part of the initial consideration amount.
But this तो PW5 has himself stated.
अच्छा,
Plaintiff himself has stated कि हमने 4,000 अपना दिए 1,000 रुपया paragraph 40 of PW5 plaintiff.
The learned counsel has referred to the evidence of PW2 as well as PW5 within bracket plaintiff to submit that it is an admitted fact that out of 5,000 deposit or out of 5,000 rupees which was the initial deposit, 1,000 was taken as loan. He has referred to paragraph 11 of PW2 who has stated that the plaintiff had sold his property to deposit the amount before the court pursuant to the order.
Exactly.
The learned counsel submits that this itself goes to show that the plaintiff was not ready and willing to perform his part of the contract during the subsistence of the contract.
Yes.
The learned counsel has also submitted that although there is an averment of readiness and willingness, but there is no averment of readiness and willingness on the part of the plaintiff to perform his part of the contract within the period of 6 months of the contract. ये लिया है appellate court.
हाँ. And on this note, same judgment notes I am the line. Lordship may kindly take a note, paragraph 26.
Yes.
Yes. Where Lord Prem Raj judgment have been mentioned. Let me place it. Sir, in so and so, the court held, it is well stated that in the suit for specific performance, the plaintiff should allege that he is ready and willing to perform his part of the contract. And if that fact is traversed, he he is required to prove a continuous readiness and willingness from the date of the contract to the time of the hearing to perform the contract on his part. From such conclusion, the judge relied upon the opinion of so. So, not from the date of the contract, it says.
The learned counsel has again relied upon the aforesaid judgment passed in the case of U and Krishnamurthy Supra, paragraph 26, to submit that the readiness and willingness is to be proved right from the date of the contract.
Date of the contract. And in this case, since he had no capacity to pay, he sold his land, he paid through
And
taking
in the
loan.
present case, there is neither any pleading nor any proof with regard to readiness and willingness to perform as part of the contract during the period of the 6 months,
6 months.
which was the stipulated period of the contract.
And
That's
now, so far as filing of suit is concerned, but same judgment, paragraph 30. That notes, the court says that it may be a desire of the plaintiff, filing of suit for getting specific performance, but that does not fulfill the criteria of readiness and willingness. Paragraph 30 notes. But after referring to the judgment notes, paragraph 38, now notes in the middle, now examining the first of the two.
Yes.
Now examining the first of the two circumstances, how could mere filing of a suit after exemption was granted to be a circumstance about willingness or readiness of the plaintiff? This at most could be the desire of the plaintiff to have this property. It may be for such a desire that this suit was filed raising such plea, but section 16(c) of the said act makes it clear that mere plea is not sufficient, it has to be proved. So only filing of suit. Court says that it can be a desire, but that does not fulfill the criteria of readiness and willingness in terms of section 16(c), and therefore filing of suit will not help in that.
The learned counsel has again relied upon the aforesaid judgment in the case of U and Krishnamurthy Supra, paragraph 13, to submit that mere filing of suit within a short period after expiry of 6 months will not be a reason to come to a conclusion that the plaintiff was ready and willing to perform as part of the contract. He submits that the same would merely be a desire to get specific performance of contract.
Now, Lord, so far as bona fide purchaser is concerned, the Lordship may kindly see, but take page 18 of the
That is
appellate
not the substantial.
No, Lord, I am only trying to defend, because this was also argued that they are not bona fide.
Is there any finding?
Sorry, yes, there is a finding by the appellate court.
Okay, that they were not going to.
No, there is a finding that they were bona fide purchaser, and because the trial court says that there was no inquiry made.
That's
It is absolutely not perverse.
no, but that is not. The
No, I am not. Therefore, I am defending that there is no substantial question of law arises to be answered in their favor. I am saying I am only defending the appellate court judgment, and I am only showing to your Lordship that appellate court have rightly dealt with. Your Lordship may kindly take page 18 of the appellate court judgment.
18.
Yes, but in considering DW4's evidence, Vijay Kumar Agarwal, have you Lordship
Yes.
got that? Yes. Vijay Kumar Agarwal, DW4, she has categorically stated in her evidence that the alleged agreement of sale was not known to her from before, nor any family member knew it. The husband of defendant number 3, Vijay Kumar Agarwal, DW4, was cross-examined on behalf of the plaintiff, and during the course of his cross-examination, DW4 stated in his evidence in para 18 that he has made inquiry about the suit property before the suit property was purchased, and he met the plaintiff Govardhan Thakur, and DW4 stated that he disclosed before the plaintiff that he is likely to purchase the suit property, and that is why he had gone to make inquiry. And during the course of talk between DW4 and plaintiff, nothing was whispered regarding the alleged agreement by the plaintiff. In this, the Lordship may also take notes evidence of DW4. Para 18, he has specifically stated that I went there, I asked the plaintiff himself, and I disclosed that I am in negotiation, I am trying to purchase this, but plaintiff did not disclose about the agreement. This has come in cross, para 18, DW4. So, what more bona fide notes? The court has considered this.
The learned counsel for the respondent has also submitted that the learned first appellate court has considered the evidence of DW4 and his cross-examination at length at internal page 18 of the judgment, wherein DW4 had stated that he met with the plaintiff and he disclosed the plaintiff that he was likely to purchase the suit property, but the plaintiff did not whisper anything about the alleged agreement. The learned counsel submits that on the basis of this, the learned first appellate court has come to a finding that defendant number 3 and 4 were bona fide purchasers of the suit property and were willing and will be protected under the provision of law laid down under section 53 of the Transfer of Property Act. Okay?
If the lordships want not, I can hand over two judgments on bona fide purchaser. But I
तो इशू भी नहीं
issue भी नहीं.
और ये इसको चैलेंज नहीं.
But जिसको भी चैलेंज नहीं कि वो question of law readiness willingness पे भी बना. Therefore, that is also not.
Readiness and willingness पर भी question of law नहीं.
नहीं बना. It
The
is
learned
only
counsel has also submitted that no substantial question of law has been framed so far as the point of readiness and willingness of the plaintiff is concerned. The question of law essentially relates to the fact as to whether the time was the essence of contract. He has submitted that for that purpose, the contract can be looked into, and on the face of the contract, it appears that the time was the essence of contract. इसके beyond तो कुछ नहीं बोलेंगे.
beyond कुछ.
एक बार agreement पढ़िए.
हाँ.
So for the point that he has.
अभी हो जाएगी.
खत्म नहीं.
इनको agreement थोड़ा पढ़ने दीजिए ना. Let's see.
आप कल से आज तक बात कर रहे हैं. थोड़ा दे तुम्हें.
कल तक मेरा खांसी बढ़ जाने वाला है.
Lord is taking so much pain, deciding all old cases, taking so much time.
तो फिर मास्क लगाने का मन करता है. Exhibit 4 है ना?
हाँ. Exhibit 4.
But
Yes.
the learned counsel has placed the exhibit 4, that is the agreement of sale, in full text. पढ़िए.
But this deed of agreement of sale made on so and so, hereby between so and so, Hazaribagh for self and power of attorney.
ठीक है, ये तो वही है.
I'm not so party position का है
Party
description.
position है.
हाँ. Then Lord's first
First
part
party is
में
the owner.
हाँ.
Then
First part is
consideration
sold
amount.
half portion Lord's first part, but second page में relevant Lord's third page. At least that the first party now agree and bind himself that within 6 months from this day will execute the sale deed respect of schedule A property in favor of second and the same be presented for registration and he will be
He will
receive the rent of rest of 25,000 or
From
the
the
consideration money from the second part. That
If the second party.
that if the second party does not get the sale deed executed by the first party in fixed time, then his advance money of 5,000 paid by the first party will be forfeited. From this date, the first party is not entitled to get rent from second party. Now, note this point that from the date of the agreement, because this has been taken note of. That if the first party refuses to execute the sale deed in respect of Schedule A property, the second party within the time fixed, then in that case the second party is free to move the court and get the sale deed executed. That the first party further assures the second party the title in respect of Schedule A property, first party is free from any defect or charge. The first party on this day 1683 after receiving the sum of 5,000 part consideration execute the agreement of with respect to Schedule A
The
property.
counsel for the respondent has, by referring to the agreement, has submitted that in order to come to a conclusion as to whether the time was the essence of contract, 3 paragraphs would be relevant. 3 paragraphs of the agreement would be relevant. Quote करिए. That the first party now agree and bind himself that within 6 months from this date will execute the sale deed in respect of Schedule A property in favor of second party, and the sale be presented for registration, and he will receive the rest of rupees 25,000, the consideration money from the second party. Next paragraph. That if the second party does not get the sale deed executed by the first party in fixed time, then his advance money of rupees 5,000 paid to the first party will be forfeited. From this date, the first party is not entitled to get rent from the second party. Third paragraph. That if the first party refuses to execute sale deed in respect of Schedule A property to the second party within time fixed, then in that case, the second party is free to move the court and get the sale deed executed. The learned counsel submits that all the steps were required to be taken within a period of 6 months.
But just to show one thing from this, although it is not recorded, that notes it says कि after this agreement,
It is already,
he is
the
not in-
council has also submitted that the extract of the agreement has been recorded by the first appellate court also.
yes, but that he is not entitled for payment of rent from the date of
ये भी
agreement.
दूसरा केस है. It's connected case.
हाँ, connected case, हम लोग
इसका भी connected case की बात नहीं कर रहे हैं, रिपेरियस से निपटेंगे. उसके बाद.
ठीक.
That's all. हाँ बताइए response.
DT.11.09.2025 there.
बताइए सर.
So for the contention of the respondent, the DW4 has stated that there was no talk with the plaintiff regarding the agreement.
नहीं no talk नहीं बोले, बोले talk हुआ but he did not disclose.
So in reply thereto, the statement of PW, the plaintiff, PW5, what he has stated in para 6 of his evidence, दीपक मित्रा एवं हीरा मित्रा को मेरे साथ उक्त एग्रीमेंट करने के पश्चात अन्य के हाथ में बेचने का अधिकार नहीं था. कुसुम लता देवी,
ये कौन है?
उमा देवी, they are defendant in this suit, in the eviction suit, or as also in this suit, they are the defendant, they are purchaser. So कुसुम लता देवी, उमा देवी को मेरे साथ दीपक मित्रा एवं हीरा मित्रा द्वारा किए गए विवाद मकान के बाबती एग्रीमेंट की जानकारी थी. That I have stated, plaintiff has stated that they had knowledge of the agreement which were executed in between the defendant number 1 and 2 with plaintiff.
In response, the learned counsel for the appellant has referred to the evidence of PW5, the plaintiff himself, and has submitted that
Para 6.
the plaintiff has specifically stated in paragraph 6
Yes.
of his evidence that the defendant number 3 and 4 had due knowledge about the agreement of sale entered into between the plaintiff and defendant number 1 and 2. और बताइए क्या बोलना
And
है?
so far bona fide purchaser is concerned, the point is not involved in this case, nor it is under challenge. There, that issue was decided in favor of the respondents, though we have taken the point in our grounds of appeal in
इस
substantial
तरह से
question
नहीं
of
हो
law.
सकता, इस तरह से नहीं होगा.
But that has, but no substantial question of law is framed. Therefore, that is redundant, what they have argued.
The learned counsel for the appellant has also submitted that so far as the point of readiness and willingness to perform the part of the contract on behalf of the plaintiff is
No, bona
concerned.
fide purchaser.
Bona fide purchase.
Bona fide.
The learned counsel has submitted that the the plea of bona fide purchaser is not the subject matter of consideration in the present case, considering the scope of the substantial portion. That's it.
But can I have what chips leave yours?
हाँ,
दूसरा second
खत्म
पिला
हो गया,
दिया।
ये तो खत्म हो गया।
हाँ।
नेक्स्ट पढ़ेंगे। नेक्स्ट कनेक्टेड फेस।
हाँ ठीक है, तो ये करें नोट तब तक हम।
हाँ करें।
एक बात।
चलिए।
नेक्स्ट केस के बाद करें।
नहीं नेक्स्ट केस के बाद नहीं करेंगे। साथ में है दोनों एक ही साथ। चलिए कॉल करेंगे। कनेक्टेड है ना?
कनेक्टेड है।
हाँ तो ऐसे नहीं होता है सर, प्लीज 2 मिनट आप करिए नेक्स्ट। Do the next case, please. Argument in second appeal number 178 of 23 is concluded. ठीक है? The suit for eviction was on default,
Yes.
period or default.
The suit for eviction was the provision of the handling legal on the ground of personal necessity.
हम बताइए सर।
Plaintiff has filed the suit.
Default for period.
Suit was filed on 31st of August.
31/8. 31/8.
1984.
1984. Default for period.
From the date of execution of sale deed, there
कहाँ से पढ़े?
जैसे कि वादी के वास्तव में अंकित तथा उसके अनुसार विवादास्पद होल्डिंग को स्वामी प्रस्तुत अभिवादीगण विभाजन मकान किसको प्रतिवादी किराएदार वाले भाग के साथ साथ उनके ऊपर तल्ले वाले भाग सूर्य पट्टी को मुद्रा के उत्तराधिकारियों से 6/4/84 को निबंधित बिक्री विलेख द्वारा 32,000 रुपये बिक्री मूल्य भुगतान कर क्रय कर लिया और तब से उस मकान का वे लोग स्वयं स्वामी बन गए और प्रतिवादी दीपक कुमार मित्रा विवादास्पद मकान के विक्रय के बाद प्रतिवादी को निबंधित पत्र द्वारा सूचित कर दिए और निर्देश दिए कि प्रतिवादी अपने भाग के संबंधित किराए की राशि का भुगतान सीधे वादीगण को करें। साथ ही वादीगण ने भी अपने पति के माध्यम से वर्तमान प्रतिवादी के साथ साथ विवादास्पद होल्डिंग के अन्य किराएदारों को भी निबंधित पत्र द्वारा सूचित करें।
इसमें कॉन्करेंट फाइंडिंग है कि रिवर्सल?
ये भी रिवर्सल।
ये भी रिवर्सल। तो एपीलेट कोर्ट का फाइंडिंग पढ़िए ना, क्योंकि फाइंडिंग ऑफ फैक्ट तो डिस्प्यूट पे नहीं है।
जी।
एपीलेट कोर्ट का फाइंडिंग पढ़िए। What is the period of default?
So period of default would be from the date of execution of the sale deed till the
would be मतलब पढ़ के बताइए कहाँ पर है, फाइंडिंग दिखाइए आप।
Para 7, finding at page 8. Para 7.
Page 8 of the
Appellate Court judgment. Para 7, it is significant to note that the argument was heard in title appeal number such as well as this eviction title appeal together, and both the cases are interrelated with each other and the parties are almost common, and that is why the judgment in both the cases are being delivered on one day, that is today, for the ends of justice. In other words, the result of judgment of title
para 10, para 8.
yes, para 8.
It is settled.
Para 7 I am referring. The result of judgment of title appeal number arising out of title suit 5684 shall automatically affect the result of the present eviction title appeal. It is made clear that in the title appeal number 892, the plaintiff of the instant eviction suit have been found and held bona fide purchaser of the suit premises. As such, the plaintiff became the landlord of the suit premises, and the capacity of the defendant Govardhan Thakur as tenant continued. Therefore, the ground for eviction in the evidence has to be considered, and the grounds have been taken. Firstly, the areas of rent as well as personal necessity, since there appears to be confusion to the defendant tenant with respect to the payment of rent because of the plaintiff became subsequent purchaser and the defendant was laying claim over the sued property illegally and erroneously and did not make payment there.
You see, the court held that in the other suit, right? The defendant number 3 and 4 have been held to be bona fide purchasers. The fact that they were bona fide purchaser is not the subject matter of dispute considering the substantial question of law framed there. So, once they were held to be bona fide purchaser of the suit property, then under such circumstances,
They became the
they became the landlord and you were supposed to pay rent.
yes. So
You became a defaulter.
So if there is any default, that is to be seen.
Did you pay the rent?
To whom? My case is that I am in possession in part performance of agreement. I am in possession of the premises in part performance of agreement, and I need not pay the rent to anyone.
Date of
Even
agreement is dated.
that agreement is 6/4/84, 6/10/83. 6/10/83. That is the agreement which is also involved in this suit, in eviction suit. In eviction suit, when I filed the suit for a specific performance of agreement, on the basis of that agreement, thereafter the plaintiff.
If you are in possession of part performance of a property, then that is a defense.
Yes, it was.
When you are seeking, when any title suit is filed, seeking recovery of possession from you, and seeking declaration of title and recovery of possession from you. So the point is that this is not a title suit.
It is all the suit.
It is only a suit for eviction under BBC Act.
Yes.
So the court will not enter into the title and will only enter into the relationship.
So court will see if the defendant here, the respondent, are the landlord.
Certainly. The court has seen
So
that.
there, since there was no relationship of landlord and tenant between the parties,
So therefore, how
the
do you...
plaintiff of this case have failed to adduce any evidence.
No. There is relationship of landlord and tenant. Because defendant number 3 and 4 were the bona fide purchasers
Yes,
of the
by
suit
purchase he claimed, he said.
Yes, by purchase it
So
becomes
he-
atonement is not necessary.
They
Atonement
are,
is not necessary.
they may be owner, but they are not my landlord.
No, atonement is not necessary. The once they become the owner, atonement is not necessary.
Therefore, the case of the plaintiff, it is not the case of the plaintiff that I ever paid any rent or
Need not.
I recognize them
No.
as my landlord.
No, you need not recognize. They have issued you notice and asked you to pay rent.
Yes, on the basis of a sale deed.
Whatever it is.
On the basis of the sale
On the
deed which
basis
was
of
under
the sale
challenge,
deed executed by, on the basis of the sale deed
executed by the real owner.
by real.
Yes, I do admit all these facts. But it is not their case that they became my landlord because I have denied the relationship of landlord and tenant between the parties. I denied payment of a single farthing to them towards rent. So on the basis of title, the eviction suit was decided. On the basis of title in earlier suit, which is not within the scope of under the provision of Bihar Building Lease Rent Eviction Control Act. It cannot be on the basis of title. Eviction decree cannot be passed. So learned lower appellate court had decided this only taking into consideration that the plaintiff of the suit is since they are bona fide purchaser, therefore they are landlord and there is need of the
transfer property. You see, the benefit of 53A is available to a person. Not only in part performance, he should be in possession of the property, but has done some act in furtherance of the contract.
Yes.
What has been done? In furtherance of the contract.
In furtherance of contract, I never paid to
No.
rent to my
Has done
the
some
original
act.
owner. हम क्या करते हैं उसको ढा के फिर से बनाते हैं हम तो अपने उसको खरीदने के लिए हमारा बिजनेस चल रहा था सैलून था बाल काटते थे
बीबीसी एक्ट का जितना स्कोप है ना उसी के अंदर ही
ना स्कोप के बियॉन्ड चले गया ना
बताइए
जैसे
ना क्या चीज़ स्कोप के
as soon as the learned lower appellate court has said that on the basis of the decree passed in earlier suit in appeal when it is held that they are bona fide purchaser he has enlarged the scope which
No.
cannot
The court is taking care of the fact that they have been held to be a bona fide purchase.
yes so on the basis of title it is being decided.
Title has already been declared.
Yes.
Being a bona fide purchaser.
So on the basis of title, how it can be decided? In the case of Rajendra Tiwari, again I am sorry that I have not.
कोई बात नहीं राजेंद्र तिवारी तो हमको याद हो गया आप जो मर्जी उसका बहस करें
Order 6 rules, Order 7 rule 7.
साइटेशन बताइए बस
2001 volume 2 JLJR. Page 890 Supreme Court. Paragraph 7, 8, 14 to 16. It is evident that while dealing with the suit of the plaintiff for eviction of the defendant from the suit premises under clause C and D of subsection 1 of 11 of the Act, court including the High Court were exercising jurisdiction under the Act, which is a special enactment. The sine qua non for granting the relief in suit under the Act is that between the plaintiff and defendant relationship with landlord and tenant should exist. The scope of the inquiry before the court was limited to the question as to whether the ground of eviction of the defendant have been made out under the Act. The question of title of the parties to the suit premises is not relevant having regard to the width of the definition of the terms landlord and tenant in clause F and H respectively, the section 2 of the Act. Inasmuch as both the trial courts as well as the first appellate court found that the relationship of landlord and tenant did not exist between the plaintiff and defendant, further inquiry into the title of the parties having regard to the nature of the suit and jurisdiction of court was unwarranted. Then paragraph 14, where the relief prayed for in the suit is larger relief and if no case is made out for grant the same but the fact as established justify granting of similar relief, Order 7 Rule 7 permits granting of such a relief to the parties. However, under the same provision, a relief larger than one claimed by the plaintiff in the suit cannot be granted. These are the cases where the courts which tried the suit were originally civil court having jurisdiction or to grant alternative relief and pass decree under Order 727. Court of Principal having limited jurisdiction to try the suit on the ground specified in a special act obviously does not have jurisdiction of ordinary civil court and therefore cannot pass a decree for eviction of the defendant on the ground other than one specified in the act. If, however, the alternative relief is permissible within the ambit of the act, the position would be different. In this case, the reason for denial of the relief of plaintiff by the trial court and appellate court is that the very foundation of the suit, namely the plaintiff or the landlord and defendant is tenant, has been concurrently found to be not established. It is evident in any event, inquiring into title of the plaintiff is beyond the scope of the court exercising jurisdiction under the act. That being the position, the impugn order of the High Court remanding the case to the first appellate court for recording finding of the question of title of the parties is unwarranted and unsustainable. Further, as pointed out above, in such case the provision of Order 727 are not attracted. For this reason, the aforementioned cases are now of no assistance to the defendant. In view of the matter, we cannot but hold that High Court erred in remanding the case to the first appellate court for determination of title of the parties to the suit premises and granting the decree under Order 727. So, my contention is that there is no finding. The finding is based on the basis of the decree which has been passed in appeal in a suit for a specific performance of agreement. Therefore, I was referring.
एग्रीमेंट है एग्जिबिट 4 वाला इसमें कौन सा एग्जिबिट है इसमें एग्रीमेंट
हाँ वही एग्रीमेंट
E1 and
एग्जिबिट
इसमें एग्जिबिट नंबर कौन सा है वही सेम एग्रीमेंट 6/10/83 का एग्रीमेंट
उसमें साफ लिखा हुआ है कि हम लोग आपसे रेंट नहीं देंगे.
इसमें भी एग्रीमेंट है उसी फ्लैट किया ये राइट सर्टिफिकेट वो फ्लैट
एग्जिबिट बी एग्जिबिट बी इकरारनामा 6/10/83. इसमें जो लास्ट का रखा है उसमें from this date first party is not entitled to get rent from second party. Agreement is cut. Exhibit V, which is Exhibit 4 in earlier suit.
आप substantial question अपना पढ़िए.
Whether in case of applicant's possession as prospective purchaser by virtue of agreement for sale, the defendant applicant can be said to be the tenant under the plaintiff respondent. Whether the nature of possession of the applicant having changed as prospective purchaser in part performance of contract for sale, relationship of landlord and tenant survive between the parties. A two substantial question. So, it cannot be said that we were tenant under the defendant, plaintiff, and we defaulted in making payment. We were acting on the basis of the agreement as prospective purchaser, and we were possessing the suit.
So I want to know till what date did you pay the rent? एक crucial question है. According to you, आपने कब तक payment की?
February 84.
What is the date of the agreement?
What is the date of?
Agreement.
Agreement dated April
April
10
6/10/83.
6/10/80.
Why did you pay the rent in 84? Even after the agreement, you continue to pay the rent. यही तो सवाल मैं आपसे पूछ रहा हूँ. Why did you pay the rent there? एग्रीमेंट हुआ, रेंट देना बंद कर दिया. दैट इज अ सेपरेट सिचुएशन ऑल टुगेदर. बट एग्रीमेंट होने के बाद भी रेंट दिए तो फर्क नहीं है दोनों में, बहुत फर्क है. बताइए. एक सवाल है आपसे पूछ रहे हैं जिसका जवाब ही नहीं देना था. डिफॉल्ट का पीरियड कब से?
Default from the date of filing of the suit, from the date of exclusion of the sale deed
आप
till filing of
बताइए
the suit.
कहाँ है? Where is it? From where will I read it? पेन दिखाइए बस. आपको पता है what is the period of default? एग्रीमेंट के बाद इन्होंने रेंट दिया है कि नहीं दिया? दिया है, बस उतना दिखा दीजिए. बात खत्म है, फिर बचा क्या है?
हाँ, this is the finding of the court.
वो दिखाई ना को मिलेगा.
हाँ. But may kindly take note appellate court notes.
Where is it?
Page 6 notes. Appellate court page 6. Have you not got that notes page 6? But Deepak Mitra, that the defendant seeing some foul motive on the part of Deepak Mitra to oust him from the suit premises, tendered rent by money order which was refused by Deepak Mitra, but he purposely refused to receive the rent of March 84. The defendant further stated Deepak Mitra and his wife, a self-holding power of attorney holder,
Refused receiving rent from March 84. Right? This is the original owner. इसका मतलब उसके पहले तक तो सारा पेमेंट. उसके पहले तक तो
but
सारा
it is
payment.
their case that they entered into an agreement on 1683, and it is their case that from that date we were not supposed to pay any rent in terms of the agreement because we stepped into the shoes as a prospective purchaser.
Yes.
So we stopped payment of rent.
Which is not correct. The non-payment of rent is from March 84. The
No.
agreement is dated October
6/10/83.
if that was their case that they became the owner and then they stopped making payment of rent at all,
Let me just see what is the alleged date and what.
alleged it is 6/10/83.
No, that is the agreement, Lord.
Yes, and you see, the rent was forwarded to Deepak Mitra by the applicant, the tenant, but they refused in the month of March 84. It means that they were tendering rent in spite of agreement. एक केस हम डिसाइड किए हैं इस पर, आप लोग देखते ही ये जजमेंट. If a person continues to tender rent
Yes.
in spite of agreement, the relationship continues. So I want to know, it is one thing to say that after the agreement you stop making payment of rent. Fair enough. But if you have not stopped making payment of rent, then under such circumstances, your relationship was continuing as landlord and tenant, and abruptly you stop making payment of rent thereafter. And atonement is not necessary. And no title has actually passed on to you. और सेक्शन 53 का केस इसमें थोड़ी डिसाइड होगा. बीपीसी एक्ट में अभी आप जजमेंट पढ़े ना, टाइटल नहीं डिसाइड हो सकता.
Yes.
हाँ तो बस नहीं
On
होगा
the basis
डिसाइड.
of degree में, on the
नहीं
basis
होगा
of-
कोई चीज पे नहीं.
On the basis of title degree भी नहीं हो सकता.
कोई बात नहीं, इसीलिए ना सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है.
जी.
हाँ तो बस उसी पे बहस करिए. जितना स्कोप है इसका उस पे बहस करिए. There is a judgment of Supreme Court जब पूरा substantial consideration दिया जा चुका है, then the rent need not be paid. There is one
There
judgment.
is one judgment, Lord, which says
हाँ.
कि अगर agreement हुआ and it is accepted by the owner,
Owner
Then-
and then in almost the entire consideration was paid by the lady
yes,
in that.
but that is P. Kanti Mati's judgment.
हाँ.
But then in that situation, the Supreme Court says that now since it is admitted that there was an agreement,
Yes.
the tenant has stepped into the shoes of a prospective purchaser, and then in that situation, landlord-tenant relationship comes to an end. That is the P. Kanti Mati's judgment.
But in a case where there is an agreement of sale, but the tenant continues to pay rent, his conduct speaks volumes. The landlord-tenant relationship cannot be said to be settled.
To that effect, it is now be admitted by the defendant, he admitted that they paid rent up to March 20.
They stopped making payment when it came to light that the property has been sold to defendant number 3 and 4. Not pursuant to the agreement. So therefore atonement is not necessary and therefore you are a defaulter.
For defaulter, 2 consecutive months is required. But in the suit was filed in August, it was got executed in the month of April.
April, May, June, July, 4 months.
2 महीना हो गया. मार्च और अप्रैल में, जून में, जुलाई में, अगस्त में 4 महीना मात्र.
देखिए छोटी छोटी चीजों से केस टू केस में फर्क होगा. बट याद नहीं है किस केस में हमने इसको डिसाइड किया. आपको वो जजमेंट याद है? वो के कांति मिट्टी का
See,
citation लाए हैं?
2002 का.
तो ये आप तो किताबें नहीं लेके आते, मेरे लिए तो पढ़ने के लिए लेके ही
मैं पूरा किताब ही आपको
आप लाइब्रेरी हम आपको दे देंगे पूरा पढ़ने के लिए. ऐसा थोड़ी होता.
This is 2009 SCC 339.
2009.
2000 volume 9 SCC, page 339. And Lord, kindly note one more judgment, Lord. This has been considered and distinguished by the Supreme Court recently, Lord, 2022 10 SEC 496.
496.
Yeah, 22 10 SEC 496.
ये दोनों होंगे सबमिशन
But can we request one thing? अगर थोड़ा सा पीछे भी एसी चल जाए, मैं बहुत गर्मी हो जाता है।
हम बहुत बीमार पड़ गए वो खिड़की खुला हुआ है कि
नहीं खुला हुआ नहीं है।
खोलिए
कल हमको लग रहा था कि हमें तो दवाई खाने से क्लॉस्ट्रेटिंग
नहीं आपको यार
नहीं ये एसी मुझसे बिल्कुल बर्दाश्त नहीं है so I'm just
But I just came from court number
I
16. It was so
had to
cold.
take 4 days leave because of this
Yes.
दो चीज के कारण AC and this dust from this
Not AC के कारण नहीं, नोट ये डस्ट के
ये
कारण।
जो dust
ये डस्ट के कारण
पुराने
होता है।
record से
हाँ।
that
Not-
is creating a lot of health hazards for me you just can't imagine
But वो डस्ट से हो रहा है नोट, AC से या ठंडा से इसके बारे में बहुत रेलेवेंस नहीं है।
अच्छा ठीक है कुछ एक मॉडरेट क्लाइमेट
हाँ, बट कम से कम पीछे भी जाए हवा सर्कुलेशन बहुत ज्यादा गर्मी हो जा रहा है। बस 16 से भी हम रश करके आए, वहाँ पे एकदम ठीक है।
पोस्ट लंच हमको चेक टेम्परेचर इसमें सेट
हाँ।
जो हमको सूटेबल
हाँ हाँ बट जो भी बट एयर सर्कुलेशन है वो पूरा बंद हो जाता है, कॉम्पैक्ट हो जाता है और उसी में
एक इंसिडेंट एक बार जस्टिस डीके राय आपसे बोले थे कि केस में फर्स्ट अपील में जजमेंट रिजर्व कर लिया, कहीं ऐसे आमने सामने भेंट हो गया, बोले यार तुम्हारा तो फाइल हम जब खोलते हैं इतना ठीक होता है कि बंद करके रख देते
इतना ठीक होता है।
ऐसा थोड़ा फाइल
ठीक है यही है ना आपका सबमिशन और तो कुछ नहीं
तो यही ना
दिवाली वाला जजमेंट और ये आप थोड़ा हमको फाइंडिंग्स दिखाइए तो ट्रायल कोर्ट फॉर्म ट्रायल कोर्ट में रिवर्सल है ना
हाँ बट बेसिकली रिवर्स को हम लोग सब दोनों सूट क्योंकि साथ में चल रहा था, उसको डिग्री हो गया तो ये डिसमिस होता और वो हम लोग डिसमिस हो गया तो इसलिए ये अलाउ हो गया, हुआ यही।
कुछ फाइंडिंग दिखाई ना इस तरह से लिखा हुआ है कुछ समझ ही नहीं what were the issues framed ट्रायल कोर्ट बिना इशू फ्रेमिंग किए डिसाइड कर
इशू फ्रेम हुआ हम लोग पैराग्राफ 3 पेज 5 पे पैरा 3 वाद बिंदु निर्धारित किए गए हैं। फर्स्ट है पैराग्राफ नहीं वो नहीं फाइंडिंग जो है फर्स्ट पैराग्राफ 4 में हम लोग से लैंडलॉर्ड टेनेंट रिलेशनशिप का पैराग्राफ 4
इसी को पढ़िए ना क्योंकि मेरी तो ये
but there is no dispute not there it is their case only।
नो नो नए लैंडलॉर्ड के साथ हुआ है
हाँ सब लोग अटोर्नमेंट वाला जो
नहीं
बात
ये प्लेंटिफ कौन है
प्लेंटिफ तो नए जो
Purchaser।
लैंडलॉर्ड हाँ परचेजर
हाँ, तो what is the finding on landlord tenant relationship between the purchaser and the original tenant
होगा।
पैरा 4 से है।
पैरा 9 में कहते हैं ऐसी स्थिति में पक्षकारों द्वारा वर्तमान वाक्य विवेकों पर लाए गए मौखिक एवं कागजी साक्ष्यों को पुनः विस्तृत रूप से वर्णन करना आवश्यक नहीं समझता हूँ और संविधान 6 दिनांक 6/10/83 के आलोक में मैं इस निष्कर्ष पर पहुंचता हूँ कि पक्षकारों के बीच मकान मालिक एवं किराएदार का संबंध नहीं है।
But they rely upon 56 of 84 specific performance वाले सूट पे, and then it has been said कि लैंडलॉर्ड टेनेंट रिलेशनशिप नहीं। तो 56 of 84 सूट का रेफरेंस है, नॉट पैरा 9।
क्योंकि वो डिग्री हो गया।
डिग्री हो गया था, वो डिग्री हो गया तो नॉट, यही बेस है नॉट, दोनों क्योंकि साथ साथ चल रहा था। Appellate court notes para 9.
Just ये बोलते हैं गलती से मार्च तक की राशि।
हाँ, ये बोलते हैं कि हम गलती से मनी ऑर्डर दे दिए।
तो मनी ऑर्डर दिए ये तो एडमिट हो गया।
लेकिन उनका भी नेक नियति देखिए, वो लिए नहीं, वापस कर
इसीलिए तो बोले कि टेंडर जो है
मार्च में वापस किया, ओनली मार्च, फरवरी तक तो एक्सेप्ट किए। अब तो मेरा जजमेंट भी लेके आए। क्या हुआ आपका उसका स्पेसिफिक परफॉर्मेंस का जो डिसाइड किया गया कि नहीं सुप्रीम कोर्ट?
I am contemplating to move. Yes.
जाना ही चाहिए, मुझे लग रहा था जाना चाहिए उसको डिसाइड करना।
हम लोग कल हम यहाँ से जाने के बाद सेकंड हाफ में बैठ के पूरा वो जजमेंट पूरा पढ़े कि हाउ टू डिस्टिंग्विश दैट वेदर सीनियर्स वुड प्लेस दैट जजमेंट फॉर रिलायंस। तो हम स्पेसिफिकली उसको पॉइंट वाइज नोट करते हैं, नोट कैसे उसमें रेडीनेस विलिंगनेस वाला इशू पे और इस पे कंसीडर हुआ है।
चलिए देखिए तो सेकंड अपील नंबर 190 ऑफ 2003, इसका प्लेन रिटन स्टेटमेंट सेकंड आपने लिखा है।
हाँ,
लिखाएंगे, लेकिन थोड़ा सा कम से कम लिखाएंगे, उसके बाद किसी डेट में जजमेंट के लिए चूज करेंगे। इसको ऐसे सब छोड़ देंगे, इसका कहीं प्लेन रिटन स्टेटमेंट खोल देंगे। नहीं, चेंबर में सेकंड आपने लिखा है, थोड़ा सा 15-20 मिनट लगेगा।
this time I thought it proper to have only one judgment of Supreme Court referring different paragraphs for different points. क्योंकि वो वाला जजमेंट पढ़ के बोलेगा बहुत ज़्यादा जजमेंट दे दिए साइटेशन एक ही पॉइंट पे, तो it went against me there. I tried to
That case was
twist
very
the jinx.
interesting. That case was very
Yes.
interesting. उनको बहुत time भी लगा.
That is why I had to approach Mr. Sinha for that.